Just look up at the wide shot. Welcome back to Law and Crime. I'm Judge Ashley Wilcott. It is a pleasure to be with you this afternoon. We are going to go straight to court in the Jonchuck case. Remember, this is out of the state of Florida, where he dropped or threw his 3-year-old daughter over the side of a bridge, resulting in her death. Now, on the stand, it's the defense, and we are having the cross-examination of Dr. Randy Otto. What I mean by that is it's a defense witness. Let's listen.
Disorder, right?
This particular one that's sort of an amalgam or combination.
Okay. So it's not like he doesn't reach the level of having a personality disorder. He actually has one.
Sure, just not kind of the consensually agreed to ones.
What are some of the defining characteristics of the personality disorder that you've diagnosed him with?
So it's other specified personality disorder could be a whole range of things, but I narrowed it to borderline and antisocial features.
And what is that? What does borderline mean?
Borderline features are things like having very difficult and problematic and stormy interpersonal relationships. That would be a trait or a characteristic of someone with borderline features or borderline personality disorder. Having poorly controlled emotions, right? That you don't do a very good job of controlling your emotions. Seeing things in black and white terms. Someone's either wonderful or they're terrible. And people in your life, you'll go back and forth in terms of your opinions of them. So it's a very unstable and a very troubling way of interacting with people. And that's the borderline piece.
And that's something that is his personality, correct?
In my opinion.
Right. And that's separate from your diagnosis of schizoaffective disorder, correct?
That's correct.
And the term borderline features, the term borderline comes from borderline personality disorder, correct?
Right. That's an agreed upon consensual definition.
Right. And there's nothing in the term borderline that means you're close to having a disorder. The term borderline defines that personality disorder.
Oh, yes. Nothing like almost or close. No, absolutely right.
Right. And you also said antisocial features. What do you mean by that?
Yes. Well, antisocial features are behaviors typically characterized by things like not meeting your responsibilities, taking advantage of other people, not following rules, breaking the law.
And based on your opinion, the defendant meets those features, correct?
He has some of those features.
Right.
Yeah. Oh, and that's features. Yes. You didn't ask about borderline. I'm sorry. You didn't ask about antisocial personality disorder.
No. We're talking about the antisocial features.
Features, yeah.
But there's enough of these features that he actually meets a personality disorder, in your opinion.
He does. In my opinion, he doesn't meet. I could have said antisocial personality disorder. I didn't. but I acknowledge that there's some behaviors he's displayed, some features, some traits he has that are antisocial in nature that are worth mentioning here.
But they rise to the level of a disorder.
When you put them all together, yes.
Right. Mm-hmm. And as far as antisocial personality disorder, the reason you did not diagnose him with that is, in your opinion, you did not see a conduct problem in his childhood years, correct?
Right.
If you were given evidence of a conduct disorder in his childhood years, that would change your opinion, correct?
Yes.
And if you were provided that evidence, then you might likely find that he does have antisocial personality disorder, correct?
Quite possibly, yeah.
All right. Does the defendant have aggressive behavior? Is that part of your disorder?
Maybe. Yes.
Well, I'm not too surprised that's a sidebar now, because the question that was asked on cross-examination was, does the defendant have aggressive behavior? Well, I think one could argue that's speculative and that's not really within the expertise. So I'd like to bring in our special guest today. Paula Notari is here with us, a criminal defense attorney. Thank you so much for joining us here on Law and Crime.
Thank you for having me.
Absolutely. So let's talk a little bit. I know on break I mentioned to you one of the things that's interesting to me in this case is we know that there was a break in the trial because there was some concern about the defendant's behaviors by his attorneys. So he's had 2 different evaluations so that they could ensure he's still competent to stay in this trial. My question is, what's the difference between the insanity defense and he wasn't capable of knowing or didn't know his consequences or that they were wrong, versus whether or not he's competent to stand trial?
Okay, competency has to do with the defendant, in this case, Mr. Jonchuck, and his present state of mind. So the determination is the experts are wanting to evaluate whether he can assist his lawyers, whether he can pay attention in court, whether he can understand the legal proceedings against him. And in this particular case, I think some of the concerns that the lawyers had was that there was evidence in their mind that he was experiencing delusions, hallucinations. He was hearing and seeing things from jurors and things that were happening that they knew not to, in fact, be happening. So I think that that was their concern, and they called for a competency exam to make sure that he was able to assist his lawyers in his own trial proceedings. Insanity, it has to do with what his mental state was at the time he committed the offense.
Okay, so now knowing that distinction, let me ask, in your experience, are you surprised that he actually had 2 different psychologists look at him to determine whether or not he's competent to understand the legal proceedings as you described and continue in this trial?
Well, I think that typically every court is different. I think it's a good practice because there's always bias, and the judge is trying to eliminate any potential bias. And in the end, there'll be an appeal in this process, and so they can always defer to the fact that there were 2 expert opinions as to his mental fitness to stand trial.
Okay, that all makes good sense. Now, the last question I had to ask is, in terms, I'm a judge part-time in Atlanta, and I typically don't hear anyone say during a trial or exhibit behaviors that make anyone question whether or not they're competent. Typically, that's all happened ahead of time. They're either found to be competent to stand trial or not. In your experience, does this happen during trials very often?
Yes. I think I just was talking to a lawyer the other day who was telling me about his murder trial, and during the trial, the defendant decompensated and started to exhibit bizarre behavior, and this very issue came up. So I think in issues where there is legitimate mental illness, and I think it's undisputed that this particular man has a history of mental illness, and he's medicated.
Right. So what we're going to do, and I just got to know, we're returning to court because they're still examining the witness.
To get that diagnosis, but if you are aggressive, that's sort of a tick. That sort of is a check on the. It can be a criterion, but you don't have to be aggressive to get that.
Did you find in your analysis of the defendant's past that he does have and has demonstrated aggressive behavior?
I think I really keyed on the domestic violence, which he acknowledged as he took some responsibility for the domestic violence, and he also attributed some of it to his ex-significant other, Ms. Kerr. So, but yeah, there was violence, yeah.
Let me talk to you about Dr. Mackless for a moment. You disagree with Dr. Mackless that the defendant is not bipolar, correct?
Correct.
And as far as his opinion that the defendant is bipolar, your opinion of schizoaffective disorder is a complete and distinct diagnosis to that, correct?
They're different diagnoses.
Right. In your report that you wrote, you would agree with me that you did not make any reference to the fact that the defendant threatened his mother on January 5th, just a few days before the murder?
I don't know if I knew that.
Does that change your opinion at all?
No.
Not at all?
No.
The statement that the defendant gave to Melody Dishman some time ago, in which he told her that if he ever got in trouble, he would claim insanity, is also not in your report, correct?
Correct.
You knew about that statement at the time that you wrote your report, correct?
Yes. I referenced it in my report.
And you would agree that on January 6th, when the defendant is with Genevieve Torres, the day before the murder, that he is goal-directed in terms of what he wants?
Yes, she described him as fully coherent and showing no problems and raising no concerns. I heard her testimony.
Right. And his behavior with her that day was logical, right?
Certainly. She clearly made that. She made that crystal clear, I think.
On January 7th, the next day, he told her that it won't matter anymore. You recall that statement?
Yes.
And then later on, when he's with the Hillsborough County Sheriff's deputies, he explains that statement. Do you recall that?
That's my memory.
Right? And he tells them that he's confident his attorney is going to get him the outcome that he wants. Correct?
That's my memory of what he told them, yes.
So when he is confronted by a statement that could indicate premeditation of the murder, he has a logical answer for what he was thinking at the time. Correct?
So the assumption is that by saying none of this matters, that's premeditation of the intent to murder.
And that it could be, yes.
Could be. And then so by him, by him saying, I'm confident that I will prevail.
Right.
That's evidence of that he's attempting to hide his premeditation deliberation.
Well, what I'm saying is when he explains that statement, his explanation was logical. That's my point, right? He makes this response, it's not going to matter anymore because I have a good lawyer who's going to help me with my case.
Yeah, that's potentially logical, sure, yeah.
You testified
I'm
that...
just saying, you could interpret it's not going to matter anymore as I'm doomed for failure, in which case saying, hey, I'm super confident, cops, this is all going to work out because I have a killer lawyer. It could just as well be that. But I don't dispute that your possible interpretation, sure.
Now, when he drove south, you testified that he was driving south because he had this delusion of an ice age coming, right?
So he said.
But when he went over the Skyway, he took 75 up north, correct?
Yes.
So that would be a contradiction in terms of the delusion, right?
He's not going south.
He's not going south. And he told you both he and Phoebe were possessed by demons, right?
Yes.
And he said both he and Phoebe had to die in order to save the world, right?
Yes.
But yet he didn't jump, correct?
That's right.
So the delusion was so strong, he had to kill his child, right?
I didn't say he had to kill his child.
Well, isn't that the delusion?
Well, that he had to kill his child. I never said that Mr. Jonchuck had to kill his child.
I'm not suggesting you did.
Yeah.
But I'm saying the delusion that he reported to you was so strong, he had to kill his child.
That was the delusion. He had to kill his child to prevent the world from coming to an end. And he had to die too.
And he had to die too.
Right.
So the argument is he followed that delusion because it was so overwhelming and overpowering that it made him do something he wouldn't otherwise do. Is that accurate?
I don't know if I'm saying his volition was impaired. right, that he was overcome, that he couldn't, I don't think I've ever testified that he couldn't control himself. What I'm saying is that he told me that it was his belief that he had to kill his daughter in order to save the world, and indeed he did so.
Right.
He killed his daughter.
And it's your testimony that the delusion is what drove him to do it, right?
What caused him to do it.
Right. And we're assuming he wouldn't normally kill his child.
Correct.
So that delusion had to be so strong that it forced him to do something or compel.
Well, there's a lot to talk about this cross-examination. We do have to take a very short break, but we'll be right back on the other side, continuing to cover this trial live. On the screen, we're continuing. We're going to go back to the trial live on Florida versus Jonchuck. Just a reminder, we're listening to cross-examination of Dr. Randy Otto, a forensic psychologist. Now, I just want to mention Ohio versus Lindsay Parton, the babysitter accused of murdering a child in her care, is also a trial that we're covering and following. You can look online if you want to see that, and we'll be going back and forth. But right now, let's return to Jonchuck.
Phoebe off the side of the bridge or something like that, but yeah, it's possible. I guess leaving the officer who you want to kill you probably is a little inconsistent with hoping the officer will kill you.
But it's a possibility. You would agree with that?
Sure.
You previously testified that the meeting with Attorney Torres on January 7th was unscheduled?
He told me scheduled. I subsequently learned it was unscheduled.
If you learned that he called before he arrived, does that make it scheduled?
I guess it was scheduled in his opinion, but Ms. Torres' description was that it was unscheduled until Mr. Jonchuck announced his intent to meet. By way of the message, she had no intent to meet. That's all I meant.
You read that email, and you brought out the fact that there was some punctuation missing?
I read a few emails, yes.
But you would agree, just because there's punctuation missing in an email doesn't necessarily indicate someone is psychotic just by reading the email.
It could be a sloppy writer or doesn't know grammar, yeah.
Right, and you would agree that this defendant didn't graduate from high school, he dropped out, and then later got his GED?
Yeah, that's true, but I mean, to be fair about this, he showed perfect grammar in his August email, right? I mean, that was perfect. He demonstrated a knowledge of punctuation, good grammar, finishing one thought, moving on to the other. And I think it stands in stark comparison and contrast to the latter email that was sent, that we're referencing.
But you're not suggesting that just because he missed some punctuation marks that automatically means he's psychotic?
No, it's not just the punctuation marks. It was the kind of moving from topic to topic and making assumptions that Ms. Torres might be knowledgeable about things that she likely wasn't knowledgeable about. That too.
Well, he was referencing his paternity case, though, correct?
Oh, he was talking about the case that she knew about for sure.
Right. Come on, That's all I have.
Neither way. All right, Paula, there are a couple things I want to talk about. First of all, I wrote it down. This witness said, and I think this is the quote, that the defendant reasonably believed that if he put his daughter off the side of the bridge, she would die. Doesn't that sound like, well, then, he wasn't insane at the time he committed the act?
Well, I think what the expert is trying to do is show that Mr. Jonchuck was suffering from delusions, and the fact that he was going to throw his daughter into the water to save the world, and that was based on a delusional belief and not something that, the prosecutor's trying to show that this was preconceived, that this was planned, that this was rational behavior. But the expert is saying just because he was able to control himself and he actually could lift her and throw her into the water, he knew that she would die, doesn't mean that he was mentally competent or not insane. The fact is that he was suffering from delusions, and that those were sparked or triggered by his mental illness. Do you see the difference?
I do. Does the delusion mean then that the other part of the statute's met, that this psychologist is supporting the theory that he didn't know it was wrong? He understood the consequences, but because of the delusion, he didn't know it was wrong?
Yes.
Okay.
That he was not aware and that he didn't know it was wrong. So he was under a delusional psychotic state. I mean, the lingo is all over the place, but the point is that he was under the influence of this delusion, and therefore he was not rational. He was not like you and I. He was not in the real world. He wasn't understanding what everyone else who's normal, functioning, experiences in life.
All right, so we're going to go back to court. Now they're back on redirect by the defense attorney.
Is getting somewhat paranoid. On another session, he describes Mr. Jonchuck as making up paranoid scenarios. That's a quote. there were the somatic hallucinations that the prosecutor and I agreed on.
What is a somatic hallucination?
So somatic is bodily. So it's a very unusual kind of hallucination. So you might think that bugs are crawling on your body. This particular hallucination, as described by Dr. Arthur, was that his skin was bubbling.
And when was that? I'm sorry.
That's what he reported. His report to Dr. Arthur led Dr. Arthur to write somatic hallucinations, skin bubbling, and then there's a word I just can't read.
When was that note?
November 2nd of 2012. There's another note where Dr. Arthur describes the defendant as paranoid, feeling very paranoid and making up scenarios. So now, I can go through the rest of all these notes.
That's okay.
But I agree that the possibility of other psychotic symptoms are suggested by descriptions of the defendant as feeling paranoid, but sometimes healthcare professionals use words in ways they shouldn't be used. So I'm making an inference based on the words, based on Dr. Arthur's notes.
And did Dr. Arthur prescribe Seroquel?
Yes.
And Abilify?
Yes.
And we talked about what Seroquel was already. What is Abilify typically prescribed for?
Abilify, off the top of my head, I don't remember.
Okay.
Sorry.
The state had mentioned that you are paid for your time, $200 an hour. Is that correct?
That's right.
Okay. Now, if you were sitting in the audience and watching other people testify all day, would you be getting paid for that time?
I get if I was hired to do that. Well, if I was hired to do it, I would get paid. Yes.
Okay. So if an expert hired by the state were sitting through trial,
Objection to approach.
Yes.
They're approaching the bench. There was something asked that they objected to, so we'll see what happens. But in the meantime, Paula, let's talk about a good point that you raised, and that is the emails. The testimony was he had an email that wasn't well written, didn't have good grammar, punctuation, etc. Is that in and of itself meaning of anything like psychosis or mental illness?
Well, so I think the point that the defense lawyer was trying to, the prosecutor was trying to show that he was not formally educated, he didn't have maybe an advanced degree, and therefore the punctuation was somehow indicative of shouldn't be taken as an important symptom of anything. But the point I think the expert is trying to make is that it was inconsistent with his prior emails, that this particular individual had it was his custom and practice to be very grammatically correct and to punctuate. And therefore, the fact that during this time period, this crucial time period we're looking at, when he's emailing his lawyer, all of a sudden he's acting differently, and his normal course of writing is different. He's not punctuating, and we all know people, our sister or our friends who have perfect grammar, and all of a sudden, 20 years perfect grammar, you get an email that's grammatically incorrect, and that's a sign of something, that could be concerning, and that's the point here.
So to play devil's advocate, though, I think the prosecution made a good point to say, listen, in and of itself, that email doesn't mean he was psychotic or insane at the time he committed it. Would you agree with that point?
Yeah, and I think the goal of the lawyers, the defense lawyers in this case, is to paint the picture, the full picture of every aspect of his life during this time period. I don't think there's one salient factor that is going to rise or fall in this case. But overall, you really want to paint the picture of this particular time frame in his life, and there's a lot of information which shows that he was severely mentally ill, including his interaction with his lawyer. I understand that she went on to call Child Protective Services because she feared for the child's life, and she believed that he was in a serious mental state, that he was acting different than he had in the past. And so that is the goal. You're not wanting to just focus on any one fact. And I think the prosecutors, their tendency is to just focus on independent acts which show in their mind that he was rational, that he was acting in a normal way, the penmanship, the fact that he was able to drive on a bridge, the fact that he was able to drive at all.
But aren't those the factors that a prosecution, again, to play devil's advocate, is going to have to look at, because they're fighting an insanity defense? And so to me, the way that you're going to do that is show, okay, here were the deliberate actions, the premeditation, all of these actions can be perceived as that. So in their defense, the prosecution has to go over that, don't they, to try to prevent the insanity defense from prevailing?
Absolutely. Absolutely. They're trying to show that his behavior was controlled, that he had control of his actions, that it was intentional, that he was deliberately trying to kill his daughter. And every question they're asking of these experts and all of the witnesses is geared towards trying to establish that.
All right, so we have some more good discussion to have. I love having Paula. She has some experience with these criminal defendants who have similar issues. We are going to go to a break. You'll want to come back. We're going to continue to cover both of these trials live. Gavel to gavel. on Law and Crime. You may recall that we covered the trial of Melanie M. 2 trials, actually, and she was convicted of second-degree murder for stabbing her boyfriend. Here's the breaking news. She has been sentenced to 50 years in prison. They have now announced that, yes, she was found guilty. You may recall that she fled the state. There's a picture of her with her boyfriend who she did stab. 2 trials covered here on Law and Crime. She has been sentenced by the judge in this case to 50 years in prison. So that's the breaking news here first on Law and Crime. And what we're going to do now is return to trial, and this is going to be the Jonchuck trial. And again, we're listening to Dr. Randy Otto, a forensic psychologist, and I believe we're going to rejoin court that he is still under redirect.
State also asked you about whether the statement, none of this is going to matter tomorrow, could be or possibly be evidence of premeditation. Did you observe evidence that was inconsistent with premeditation, with the premeditated killing of Phoebe?
Well, what I would say is I thought that if he left his house with the idea of killing Phoebe, he did it in a very clumsy way, insofar as he engaged in a string of behaviors that really drew attention to himself. And if you were thinking clearly and you're not impaired by symptoms of severe and persistent mental illness, in my opinion, that's not how you go about doing it. That's my rational, that's my logic there and my thinking about it.
Well, would it make sense that he was...
Well, let me say this. I'm sorry.
No.
I also think it doesn't make a lot of sense.
Non-responsive.
I also think it doesn't make a lot of sense if you're intending on killing your daughter later in the day to act in such a way that you draw the attention of organized law enforcement, to get your attorney to breach attorney-client privilege and call the cops on you when you know the police are fully capable of hauling you in for involuntary examination, what most people refer to as a Baker Act, right? I don't think it works to your advantage if your goal is to kill if the goal is to kill your daughter, to draw all kinds of attention by behaving in ways that get people that arguably might get people concerned, putting salt under the doors and claiming Bibles are knocking and your daughter's chanting and she's possessed and you're the Pope and all of that. As I interpret that, I think that's inconsistent with someone who is planning to kill his daughter and move on.
Well, what would you say that there was, I guess, so it's premeditated and then he just throws in these things to claim insanity. Does that make sense?
Okay, well...
Again, it's leading, Your Honor.
So, all right, I'm going to kill my daughter and I'm going to lay this trail of breadcrumbs to get the insanity defense. That may have started then in 2011 and 2013 when he was treated for significant impairments by Dr. Arthur. So that, I don't think, in fact, 2011, I don't believe Phoebe was alive at that point in time. But the history of psychiatric symptoms long predates these events.
May I have a moment, Judge?
So we are back on redirect by the defense, who called this witness, Dr. Randy Otto, forensic psychologist, and he's testifying quite a bit about all the specifics behind the behaviors, the diagnosis, and how he has determined that, in his opinion, the defendant was insane at the time that he dropped his 3-year-old child, Phoebe, off of a 62-foot bridge. Now, that's about 6 stories on a building. So you can imagine, certainly you'd be aware that if you did that to a child, they're likely to die, which in fact this expert said. We're going to go back into court. Bring you back in and ask you, first of all, we talked a little bit before about some of the behaviors, and there was one you mentioned about, listen, we all do things on autopilot. So a lot of the things that he did aren't necessarily premeditated or deliberate as much as it is he was just on autopilot.
Yeah, I think that the prosecution here is trying to show that the defendant, Mr. Jonchuck, was the fact that he was able to drive a car, the fact that he was able to write a letter, that somehow these actions were consistent with his sanity, the fact that he was in charge of his actions. And in fact, the case is that many people who are mentally ill are acting on autopilot, just like in your own life, when sometimes you're daydreaming and you find yourself in another room and you don't even remember walking from one room to another, eating and basic life functions are things we do on autopilot. So the fact that he was able to drive, the fact that he was able to write, the fact that he knew which direction the bridge was in, these are not indicative necessarily of the fact that he was mentally sane.
All right, so he is continuing to answer questions. Let's go back to court.
But I agree they're inconsistent, but that's because that was completed before this, I believe. The somatic hallucination note.
That's your opinion that this is an intake form?
I think I mean,
It mentions
I have a factual basis for that.
It mentions an adjudicator at the top.
It's not an intake form. You're
not
right.
an intake form.
No, it was a claim, some kind of claim.
Right.
Yeah.
For benefits like disability benefits, correct?
Right.
Right. And Dr. Arthur noted none reported on the section for hallucinations and perceptual disturbances, correct?
Yeah, just now I'm confused because.
Do you need me to approach this again?
Maybe because what I have here doesn't have all pieces of the form.
Now, we're going to continue to cover this trial and the Lindsay Parton trial. We do have to take a very short break, but you won't want to miss this live coverage on Law and Crime.
Did you know you could be taking advantage of everything AARP has to offer right now? Join today for just $12. Find out what 37 million AARP members already know. Benefits start instantly.
It's AARP.
Are you joining AARP?
Actually, I just did.
But is it worth it?
I enrolled at 7:02, saved on concert tickets at 8:10, read a great article on investing at 9, found a sweet travel deal at 10:15. I used the caregiver finder for my dad, and done. Discounted movie tickets.
Call or go to getaarp.org to join today for just $12, and your second membership is free. And get instant access to discounts on eye care, prescriptions, savings on travel, dining, and deals from top retailers. So many ways to save. Instant resources, tools, and tips to help manage your money, maximize your health, and so much more. AARP is mobile. Get alerts to savings and events near you. And AARP is the largest advocacy group for people over 50. Your voice will be heard.
I love the local retail discounts. AARP absolutely pays for itself.
I'm nowhere near ready to retire, and AARP has been a tremendous resource for that.
I get reliable financial tools and tips.
And we check out the hotels, the dining. AARP saves us a lot of money.
Join today for just $12 for your first year. That includes a second membership free. Plus, you get the award-winning AARP The Magazine.
I love the magazine. Everything in there applies to me.
Benefits for both memberships start instantly. So call or click to join AARP today, and you get this travel bag and AARP The Magazine free.
Call 1-800-411-8550. That's 1-800-411-8550.
Or go to getaarp.org.
Welcome back to Law and Crime. I'm Judge Ashley Wilcott. Just to update you, the Ohio versus Lindsay Parton, the babysitter accused of murdering the young child, that trial is figuring out if they're going to take a break right now or not. So we're going to stay in the Florida versus Jonchuck. We are listening still to the redirect examination by the defense of Dr. Randy Otto, and he is the forensic psychologist.
And we have Pontiac. We have mental disorders. We have psychoses, schizophrenia, schizoaffective disorder, psychotic disorder, secondary to traumatic brain injury. So I'm not saying that if you're psychotic, you're not mentally ill. I'm just saying that that's not a specific mental illness. That's the distinction.
Did that answer your question, Mr. Miranda?
Yes.
Okay. The next one is from Ms. Resto. When did John stop using drugs in 2014?
He reported anywhere between 2 and 4 weeks before. He inconsistently reported between 2 or 4 weeks before the end of the year.
Does that answer your question, Ms. Resto? Okay. This is another one from Ms. Resto. Could it be possible that the email with no punctuation could have been voice to text rather than him typing his email on a computer? You want to see it?
Yeah, that's... I'm not very sophisticated about this, I guess. Oh, I use it, but I'm not very sophisticated. Possibly. Yeah, good point.
The next question from Ms. Resto. Could hallucinations, delusions, psychosis have been caused by the use of spice, crystal meth, or ecstasy in 2014?
In 2014, yes. Those drugs can cause those significant impairments, those significant symptoms, yes.
And then from Mr. Hoffman, in all the medical records made available to you from all sources, are there any x-rays, CT scans, MRIs, endocrine labs looking for organic defects, injuries, genetic malformations? Question. Want to see it?
Sure.
And then there's 2 others.
It'll give me a little more time to think about it.
Okay.
There were labs done. Anytime you enter almost anytime you enter a hospital, there's going to be labs. Oftentimes when you enter jail, there's labs. I don't remember any labs that were remarkable or relevant to understanding Mr. Jonchuck and his psychological functioning. There were MRIs that I observed, but they were about his back injury, and they were positive for bulging discs and things like that, but I don't think that's what we're asking about here. I don't remember seeing any brain x-rays or CT scans or MRIs or PET scans. I don't remember none in the forensic hospital record, certainly none in the jail record. I didn't see any of that. Could these things be factors or causes of alleged mental illness of the defendant? I mean, possibly, but it was never identified by any of the treatment providers or examiners, those kinds of impairments. And then there was another question, Judge?
Yes, if you could read it and then answer.
Was an IQ test administered? I don't believe any person who's ever evaluated Mr. Jonchuck, whose work I've seen, or any treatment provider has ever administered an IQ test. So his IQ has never been formally assessed by way of a test. I didn't see such records.
Does that answer your questions, Mr. Thomas? Okay, thank you.
And I didn't, obviously.
Anybody else have any other questions for Dr. Otto? Yes? Okay, take your time.
I didn't write it down.
Yeah, you should write it. It's a better practice. Thank you. Take your time.
So here's the practice. It's not true nationwide, but in the state of Florida, it's one of the states where the jury can ask questions of the witness, and they do that by writing down the questions, giving them to the judge, who then reads the questions. Paula, one of the last questions the jury asked was an IQ test administered to the defendant? And the answer was, by the psychologist, not that I saw. Boy, to me, that points to the fact the jury's thinking about, was he smart enough to be manipulative to have made all these actions as if he were insane at the time? What do you think?
I think it's a very interesting practice. It's not all over the country that jurors are allowed to ask questions of witnesses. I have actually never seen it myself. But I agree. I think that the jury is really just thinking all over the place, asking for their brain scans done, medical exams, and they're really trying to determine whether this was his manipulation, whether, how smart. And I agree with you. I think that it's a very telling question, and I think it is along the lines of trying to determine whether he was smart enough to manipulate these proceedings.
And I want to ask a question along those lines. You can just see that they're at another sidebar with the court. So, Paula, we talked about this. To me, obviously, it's a hard task for any jury to decide, based on evidence, did a person commit this particular crime? I think it's even harder for the jury to have to decide, well, we know he did it in this case, but was he insane or not? What do you think about a jury's responsibility for sifting through evidence to say either he knew what he was doing, knew it was wrong, or he was insane at the time he committed the act?
I often think, the process that we have, the jury system, is brilliant and wonderful, and it separates us from countries that don't allow that. But definitely there are times when you think, wow, this is so complicated and so difficult, this burden to put on normal citizens to determine whether this individual suffering from mental illness it's almost an unfair burden. But I think that in the balance of society, it's a good thing.
So we're going to go back to court. I think they're resuming the questioning with Dr. Otto. Let's see.
If his intellectual functioning was significantly compromised. No mental health professional who's ever examined or treated Mr. Jonchuck has raised the issue of intellectual disability, what we used to call mental retardation in the old days. So I suspect that no IQ tests were administered because no one ever had questions about whether his intellectual functioning was so impaired that it might be worthy of consideration. So if an IQ test was administered, and he did terribly on the test, so terribly that he scored less than like 2 or 3% of the population. And along with that, he showed deficits in adaptive behaviors, ability to live independently, going back to his childhood. Then we could add a diagnosis, intellectual disability. That's a mental disorder. That's a diagnosis. But I don't think Mr. Jonchuck has ever acted or functioned in a way that's ever made any mental health professional who's looked at him say, hey, I think he might be limited intellectually.
Thank you, Mr. Miranda. Does that answer your question?
Go ahead. One more thing.
Sure.
Well, we are again continuing to cover this trial, this Florida versus Jonchuck. It's been fascinating because, again, he had some behaviors. His attorney said, listen, we think he may not be competent yesterday and this morning to continue with this trial. He was evaluated by 2 different psychologists who said he was competent. We're going to continue to cover this trial. We have to take a break. Please come back on the other side and we'll continue these 2 trials, gavel to gavel, on Law and Crime. back here on this Wednesday afternoon, and we're going to resume going back into court live. Again, this is Dr. Otto, and this is the defense asking redirect questions.
You may be born with intellectual limitations. Not a concern with Mr. Jonchuck. You can have problems with attention. You can have all kinds of emotional and behavioral and cognitive challenges if your mother is abusing drugs or alcohol while you're in her stomach.
May I have a moment, Judge?
I have nothing further. Anything further from the state? I hear a ripping.
He raised this question for me.
Okay, no problem. Jurors are encouraged.
Entirely my fault.
All right, another sidebar. Now, this isn't unusual. We've seen a lot of these in this case, a lot of objections. Paula, let's talk about a couple of things that I wanted to clarify, and that is we know that this defendant decompensated. I think that was a word that you used, and his attorneys were concerned about his competency. We know he had 2 evaluations. Is any of what he allegedly said or did causing his defense attorneys to raise that concern something the prosecution can use against him, for instance, in their closing statements?
No. The only thing a prosecutor is allowed to comment on during their closing arguments is actually evidence in the trial. So anything that has to do with the demeanor of the defendant while he's sitting at the table, or anything the defendant does, that's not admissible evidence.
Right.
On the other hand, if I have a moment, what the witness does on the stand, whether a witness is evasive, the way the witness answers a question, that is something that the prosecutor or the defense lawyer can comment on during closing arguments.
All right. Okay. So one more piece of that then, and that is the jury, in my experience, if I'm watching, they typically watch the defendant. They want to see what is that defendant doing. So I'm assuming they've probably done the same and were watching any of his behaviors in court. What do you think?
I think that it's the natural tendency of jurors to always look at the defendant. In fact, defense lawyers are constantly instructing their clients to behave and not act out in court because the jury is watching them. So absolutely, that's true. But remember, the jury is going to be instructed that the defendant has the right not to testify, and therefore, and it's a very important right. We could talk about that, but a prosecutor commenting on a defendant's demeanor is along the lines of requiring them to testify, speculating about things that the jury should not be considering in this case.
So we can see, I think they're still at a sidebar. We're looking at them, looking at the screen right now to see they're looking at jury questions. So again, in this process, they get to look at those jury questions before they've asked the witness. Now, I don't want to miss that. Let me just glance at the screen. Let's go back to court and see if they're going to ask any of those questions.
Symptoms during time of incident. Question? That's a question. Yes. Okay.
Yeah, I don't think withdrawal. I wouldn't think about withdrawing from those drugs as causing the symptoms or impairments he reported experiencing.
Does that answer your question? Anyone else have a question? No? Okay.
I do have one follow-up to that.
Yeah, go ahead.
Dr. Otto, the timing for the drug use, did Mr. Jonchuck indicate that he had stopped using drugs sometime before, I guess 2 months before, but there was a relapse, there was a one-time relapse between 2 and 4 weeks?
In December of that year, correct.
Okay.
Anything further? Anybody have an additional question based on that question? Okay. Excused or stand by?
We'd ask him to stand by.
Okay, so Dr. Otto, you're on standby. Thank you for your testimony.
Thank you.
Well, you can see that this witness, I believe, is done. And Paula, I'm going to bring you back in. Now, of course, I had all these great questions, and I've been focused on the trial, and I forgot what some of my questions were. But one of the ones I want to ask you is, again, about the defendant in this case and the jury having to make the decision. And would you, if you were the defense attorney in this case, would you put him on the stand?
Absolutely not.
Why not?
Because that typically opens the door to questions. And I think there's, it's the very rare situation where you want to put your clients in the stand. Sometimes you actually, if you're, for example, if it's a self-defense case, you have to pretty much put your clients on the stand unless there's independent evidence. But in a case like this, it's a no-win situation because if you say the wrong thing, the jury is going to focus on that, and it's going to detract away from what they're really focusing on, which is his mental state at the time of the offense. And you're going to focus on his mental state currently, which is not really the issue.
And I think if you look, and our producers are right on it, because they're showing him in some of his behaviors when before he'd been a little stoic, then he's laughing and looking up and acting differently. I think necessarily the jury's going to start looking at how he's behaving now, which is why I think it's such a hard task. Juries are sophisticated, I believe, in our system, but it's a really hard task to say, regardless of what he's doing right now, he's competent. We have to look at what his state was at the time he committed the crime.
And that's why, ultimately it's the job of the defense lawyer to really, during closing arguments, to really explain to the jury what their task is. And of course, the jury will receive specific instructions as to how they are supposed to consider the evidence. And at that point, all of it should come together, and they should understand that it's not about the way he looks in the courtroom today. It's about what was happening on the date of the offense.
Right. So it's going to be interesting to see what they do. Let's do this. I'm fascinated by the whole competency aspect that came out in the middle of the trial. So what we're going to do is listen to testimony from the first psychologist who evaluated him, again, after his behaviors changed, after defense for his representation said, listen, he's not remembering some of what happened in court, and he thinks somebody testified on a day they didn't. So we're concerned about it. And let's listen to the first psychologist who evaluated him for competency.
Dr. Foreman, have you had a chance to evaluate Mr. Jonchuck?
I did, Your Honor, and I just talked to Mr. Jim Jones at the jail with regards to his medications and any symptomatology. According to Mr. Jones, the only medication he's missed is a constipation medication. He's been taking all his regularly prescribed psychotropic medications. They're planning on giving him his next Haldol injection on 4/11, which will be a month. And according to Dr. Hernandez, this is per Mr. Jones, the medication of Haldol, the injection, would not necessarily wear off, so that his level should be the same. It's just a matter of he can only get them once a month. Based upon my interview with Mr. Jonchuck, my opinion is that I think he is still competent within all 6 criterion.
You just heard it. She said the first expert that looked at him for her competency said, no, I do believe that he's still competent to stand trial, and here are the reasons. However, they had a second expert psychologist evaluate him. Let's see what his results were.
Yes, sir, I did.
And what caused you to conduct that interview?
I received a court order from the judge to do a competency evaluation on Mr. Jonchuck.
And did you do that, have you just recently completed that evaluation?
Yes.
And could you tell us what your opinion is regarding Mr. Jonchuck's competence to proceed?
He's competent to proceed.
No other questions, sir?
Any questions from the state?
No, Judge.
Okay. Defense, are you stipulating pursuant to Dr. Foreman and Dr. Cipriano that he's competent to stand trial?
Judge, we can't stipulate that he's competent. We will stipulate that the court can make your ruling based upon the reports of Dr. Foreman and Dr. Cipriano.
Okay. You want to say anything, Mr. Bowen?
Well, if that's the case, before Your Honor makes a ruling, I would ask Dr. Cipriano if he could just put on the record the facts and details of what he's making his opinion.
You want to question him about that?
I think that he could just put on the record why he's formed his opinion in the 6 criteria without necessarily be questioning him. I think he could do that.
Can you tell us, pursuant to the 6 competency criteria, Do you have those?
Yes.
Okay. If you could tell us, go through each criteria and any information that you would customarily give. Thank you.
I'd asked him what he was charged with. He told me first-degree murder. I asked him if he could explain the allegation. He told me that it was alleged that he killed his daughter, Bobby. I asked how that happened. He said how she passed. He said drowning. And then I asked him how did they connect him to the crime. He said a cop saw me do it. I'd asked him then the possible penalties. He told me life in prison or not guilty by reason of insanity, and that the death penalty had been taken off the table. I asked him then about the adversarial nature of the proceedings, in particular what the role of the judge was, and he told me act as a referee, keep order in the court, supposed to be neutral. I then asked him about the role of the defense attorney. He said to defend me and to protect me from the state side.
So some interesting things happened. First of all, you heard both experts did say that he is competent to stand trial, so trial continues as to the defendant. Paula, talk about the stipulation. We both wrote it down. So we heard his attorney, defense counsel, say we cannot stipulate that he's competent, but we can stipulate that the judge is making an order based on the expert's testimony. Flush that out for us.
Well, so a stipulation is something that the parties end to when there's a fact and evidence that they're not disputing. So, for example, in a case where a person is charged with drugs in their car, cocaine, the parties may stipulate that the substance tested positive for cocaine, but they're not going to agree to the fact that their client knew that the drugs were in the car. So in this particular instance, the defense lawyers are the party that moved for the competency exam. So it's their belief that their client is not fit to stand trial, and so they're not going to stipulate to that because they'll be held to that in a later proceeding if this goes on appeal and there's an issue as to whether the client was fit to stand trial. That stipulation would be raised and the appellate issue would no longer be valid.
Now, I'm going to assume we're going to see an appeal if, in fact, the jury says not insane, there's a conviction, appeal. Yes or no?
Absolutely. Yeah. I mean, these are generally any case that goes to trial where there's no plea bargain. For the most part, there's always your right to appeal, and defense lawyers pretty routinely always pursue that right to appeal.
All right. So we're going to take another short break. Please come back on the other side. Again, two trials that we're covering, Jonchuck and Parton. We'll resume shortly. Come back. Welcome back. I'm Judge Ashley Wilcott, and I love me a good trial, which we have two of them going on. Now, Florida versus Jonchuck is on a break. We expect that they'll come back at 4:15 Eastern Standard Time. In the meantime, we're going to listen to some testimony. Now, this was offered by the defense before they had a break in the trial about the competency issue that came up. And this is the defense's psychologist, Dr. Scott Mackless, and he was being cross-examined by the prosecution. Let's listen.
In September of 2014, he also heard the voices getting louder, right?
That's when they initiated, he reported.
Now, he reported to you that in September of 2014, when the voices were getting louder, he noticed that when he was using drugs, that had an effect on the voices getting louder, right?
That increased it, yes.
It increased it. What kind of drugs was he taking in September of 2014 when the voices were increased?
He reported that he was smoking spice.
And what else?
He used crystal meth a couple of times.
Now, as a doctor who's conducting your sanity evaluation, you have to eliminate drug use on the date of offense, correct?
Yes.
Because if he's on drugs when he commits the murder, then he's not insane, right?
That is what case law says, yes.
So if he is on drugs when he commits the murder, and that is what is causing the psychosis, if the drugs are causing the psychosis, then he's not insane, correct?
Then I would not give that opinion.
That he is insane, right?
That he was insane.
And in this particular case, you're relying on the defendant telling you that he was not using drugs on the date of offense, correct?
I'm using his self-report as well as the reports of family members who observed him that month, as well as individuals who evaluated him at that time, police officers, as well as attorney and priest reports that indicated that he did not appear to be under the influence of alcohol or drugs.
And as far as mental illness goes, you agree that mental illness does not, or the presence of mental illness doesn't automatically equal insanity, right?
Correct.
There's a second prong to that, correct?
Yes.
You have to, in order to be insane, not understand the nature of your actions, the consequences, right?
Correct.
Or you don't understand the wrongfulness of your actions, correct?
Correct.
Okay. In your opinion, did Mr. Jonchuck, the defendant in this case, know what he was doing when he dropped Phoebe off the bridge?
Factually, the information that I have is that he did have that information. He did have that appreciation.
So you believe he understood that he was killing Phoebe by throwing her off the bridge?
No, for that there is mixed messages, so that because there's mixed information about that, I'm not able to give an opinion.
So you don't know if he understood the consequences or not. Is that your opinion?
Correct.
And when you interviewed him, he wasn't displaying psychotic symptoms during your interview, right?
He was not displaying hallucinations or delusions, although his thinking was disorganized and that he was very distractible. He was jumping from topic to topic, and I had to keep him on track in order to get the information in which I needed.
But no delusions or hallucinations, right?
Correct.
He was talking about psychotic symptoms.
Let him finish. Okay, thank you. You can finish now.
Correct. He was being medicated at the time, and medications were addressing his hallucinations and delusions.
Now, prior to your interview with him, you're aware that the defendant had read the police reports in this case, correct?
Objection. Proper. Overruled.
I don't know exactly what information he obtained about the offense.
So that is the psychologist that the defense had on the stand, and he was being cross-examined by the prosecution. But the point of that expert is to say, hey, he was insane at the time he committed the act. Here is my struggle in any type of court case like this. You have to necessarily look at the defendants before it happened, after it happened, and evaluating whether or not he was insane at the time he committed the act. But by doing so, I think you can equally argue it was deliberate, he was manipulative, he knew what he was doing based on the before and after, or in the alternative, no, the before and after are indicative of mental health issue that caused him to be insane. How in the world can a jury decide which of those two things it is?
Well, I think in a case like this, it becomes a battle of the experts. And one of the things that we haven't seen, or I've not seen, at least today, was psychologists, forensic psychologists who testify, or psychiatrists, are able to actually assess malingering. There's a scale that they can, there is always a determination in a psychological evaluation as to whether there's a belief that a defendant is malingering, which means, you know, can they create symptoms, and they'll give them a test for that. They can give them a test. I don't know if they always do, but it's definitely a consideration in every case where a defendant puts forward a mental health defense.
And it's been interesting because the jury questions that were asked of the most recent witness a little bit ago, the jury focused on tests. Has he had this kind of test? Did he have a brain scan? Did he have an IQ test? So the good news is I believe that juries are sophisticated. They're taking all this information into account to determine whether or not he was insane. How difficult from a defense attorney's perspective, no matter what the evidence, how difficult is it, in your opinion, to get a jury to understand it doesn't matter how he's acting in court right now or at any other point in time, it's all about when that incident occurred?
It's very unusual, in my experience, for defense lawyers to actually prove, win is a strong term, but to actually get a jury to find insanity. And I think part of the problem is that the actions of the defendant are very scary. In this instance, he did a horrible act. He threw his child over a bridge, which is the worst thing anyone could possibly do. And it scares people, and mental illness scares people. So it's a really hard task. It's not easy. It's not easy to put forward a defense, mental health defense. I think the defense lawyers themselves have to become experts in all of these different disorders they're talking about, the medications. They often will get an expert that they don't like. I mean, that's not uncommon, where you know, just because you're hiring an expert doesn't mean you're going to like the answers, you're going to like the way they're testifying. And in many ways, you can see for yourself when you're evaluating these two experts, you just may like one better than the other. I was watching this last expert, and he had a really different demeanor than the previous Dr. Otto, who was very different. So it very often becomes a determination of so many things beyond what happens on the date of the offense.
And to your point, I found Dr. Otto was very credible, very charismatic, and you pointed out he used examples. He made it common sense understandable for all of us, and I think that plays into which expert the jury's going to believe.
Yeah, absolutely. I think he was very academic. He had a really impressive demeanor, and these are things that, as a defense lawyer or a prosecutor, because prosecutors also call mental health experts to challenge the defense experts, or for many reasons. And you're as a lawyer, you're always thinking about this, you know, the record of the expert, how they testify, whether they have jury appeal, whether they're easy to understand, whether their examples are common sense examples that the jurors can relate to. These are all considerations.
All right, and I believe in our jury system. We're going to take a short break. We're going to come back on the other side to more Law and Crime, covering trials gavel to gavel. right back to Jonchuck because there is a deputy conveying information to the judge about a juror request.
Another suggestion?
Judge, I think you to the bench if you want it for the record purposes, but I don't think you have to ask anybody who asked the question. You can just say
The Supreme Court says you should. You should say, so-and-so, is this your question? And after the answer, has your question been answered? So I can just say number instead of name.
I don't think that cures that person's problems. You're still pointing out who
well,
as a group, does that...
Oh, I see what you're saying. Well, what about if I use the other numbers that jury services gives them? You can't really make any head or tails of that. Because it's not.
All right, it was hard to tell what was going on by watching, but I can tell you our own Kathy Russin was able to clarify. A jury member has indicated that they are uncomfortable with their name being read out before the question is asked by the judge. And you'll notice when she asked jury questions, she said the person's name and then the question. They don't like that. Now, to me, it could be you just number the jurors 1 through 12 and say juror number 1, juror number 2. But I don't know how they're going to resolve it in their court, nor do I know the Florida rules around that because it's not a practice nationwide, only in some of the states. We are going to return. We were previously watching testimony, and this again is prosecution cross-examining Scott Mackless. And this is a psychologist that testified on behalf of the defense, stating in his belief that the defendant was insane at the time that he committed the act.
All right. In that statement, Melody Dishman reported that the defendant told her being Melody, that if he ever got in trouble one day that he would claim insanity. Correct?
Yes, when he was 12 years old.
Right. And he said that to her, according to her, when they were 12. Right?
Correct.
But at the time that you reviewed that police report, you didn't know how old the defendant was when he said that to Melody, right?
Correct.
You didn't know the context of that, correct?
Correct.
You didn't know where they were when he made that statement at the time that you reviewed that police report, right?
Correct.
But yet you discounted that statement in your opinion without knowing the context of it, right?
No.
Did you know the context of it?
I did not know the context of it.
Did you call Melody Dishman and ask her what the context of it was?
No.
Did you do any research to try and find out what was the situation when he said that statement?
No.
But you didn't reference that in your report that you provided to the defense, did you? That statement that the defendant made to Melody Dishman, you did not reference that in your report.
I have to go through my report to see if it's in there. I did not see it in my report.
Right. So you cherry-picked from that interview with Detective Miller parts that were good for you and excluded a part that was bad for you, correct?
Argumentative.
Overruled.
Correct?
What I put into my report and what I used as evidence and information in expressing my opinion was information that was corroborated, information that there was extensive information about, that I could really use that information to give an opinion regarding that information. And it just was indicated. There was no context for that statement. There was no timeline for that information. And just as it came out in her deposition, this was a statement that was made at 12 years old, which to me is inconsequential in regards to the offense in which we're talking about.
But you've already testified that in your opinion, we go all the way back to 5 years old when we talk about his mental health, correct?
Yes.
So childhood is important. And what happens in childhood is important, right?
Depends, and to a degree. What's most important is the time period before, whether it be weeks, months, maybe a couple of years before. Certainly what happened in childhood is less important than what was important in one's 20s, in this case, in John's 20s, and moving forward.
Well, you would agree that childhood is important if you're looking at the defendant for a diagnosis of antisocial personality disorder, correct?
No.
No?
No.
a conduct disorder is required in order to have a diagnosis of antisocial personality disorder, and that conduct disorder has to begin in childhood.
Yes, so first you would be looking at the diagnosis of conduct disorder when they're in childhood.
Right. That's my point.
Dr. Mackless testifying for the defense, and that was cross-examination by the prosecution. Paula, I'm going to put us both on the spot because we were talking on a break, and I'm going to say it here. When you talk about a battle of the experts, I think a lot of the times with the jury, it's not necessarily the details of what they're saying as much as it is their appearance, their personality, how they come off, if they're relatable or not. How much does that play a factor?
I've often thought that it's unfortunate that life is life, and how much you like the lawyer, how well the lawyer does in court, often has nothing to do with the person who's on trial. I mean, often a lot of these individuals have court-appointed counsel, and they have no say-so as to who represents them. It's just a luck of the draw, and so many of these decisions go on to affect their liberty and. We saw in the OJ trial, he had the dream team, so he got off, and if someone else had the same set of facts, but a different trial team, wouldn't be the same results.
And I will say this, I believe in our jury system. I've said that, and I stand by it. They're very sophisticated. They make good decisions. But this case, I think, is a very hard decision they're going to have to make. Now, we're going to return to court. We do have, I think the judge has said, okay, I'm not going to use the juror's name, resolve that issue. Now we have the next witness on the stand, and this is a defense witness. Let's listen.
And number 7, can you take a look at Can you take a look at that and see if you recognize what that is?
Yes, that's the second Bible taken from Mr. Jonchuck's car.
Okay. And is it in the substantially same condition as when it was recovered?
Yes, it is.
Judge, at this time, we'd ask to introduce what's been pre-marked as Defense Exhibit 7 into evidence as Defense Exhibit 7.
Any objection? Received.
Is the glass in the book? Do you believe that's from when they smashed in the windows?
Yes.
And what is, I'm sorry, I shouldn't take it from you. What kind of Bible is this one that was recovered?
It's the Gideons.
Best you recall, was there a Catholic Bible in English recovered from Mr. Jonchuck's car?
No, I don't think so.
I'm showing you what's been marked for identification as defense number 6. If you could take a look at that, let me know if you recognize that.
Yes.
And what is that?
That's the Bible that Melanie Dishman gave us.
If you want to open it,
Sure.
just take a look and let me know if it's in the same condition as when you went to that.
Yes.
Judge, at this time, we'd ask to introduce into evidence what's been pre-marked as defense number 6 as evidence defense number 6.
Any objection? Any objection?
You indicated that Bible came from Melody Dishman.
Yes.
Was it something that she? I guess where did she get it from?
She said that was the.
This is hearsay.
It's the same.
What was your understanding of when Mr. Jonchuck had moved out of Melody's house?
Around Halloween of the previous year, which would have been 2014.
Sergeant Miller, I'm showing you what's been pre-marked as Defense Exhibit 12 for identification. Do you recognize that?
Yes, this is Mr. Jonchuck John's cell phone.
And is it in the same or substantially same condition as when you saw it last?
Yes.
Judge, at this time, we'd ask to move into evidence what's been pre-marked as Defense Exhibit 12 as evidence defense.
Objection.
Sergeant Miller, after you testified last week? After you testified last week, I had asked you some questions about when that phone was put into evidence. Is that correct?
Yes, you did.
Did you go back and try to obtain that information from the jury?
Yes, I did.
And were you able to ascertain when that phone was actually placed into property and evidence?
Yes, it was April 23rd, 2015.
I'm showing you what's been pre-marked as defense number 2 for identification. You take a look.
Yes, it's a $100 bill, cash.
Okay. And judge asked to move into evidence, defense number 2.
Can I see that?
Oh, yeah.
No objection, Your Honor.
What?
So this is a witness who testified for the prosecution. We have to take a very short break. Come right back on the other side.
If you're over 50, did you know you could be taking advantage of everything AARP has to offer right now? Join today for just $12. Find out what 37 million AARP members already know. Benefits start instantly.
It's AARP.
Are you joining AARP?
Actually, I just did.
But is it worth it?
I enrolled at 7:02, saved on concert tickets at 8:10, read a great article on investing at 9, found a sweet travel deal at 10:15. I used the caregiver finder for my dad, and done. Discounted movie tickets.
Call or go to getaarp.org to join today for just $12, and your second membership is free. And get instant access to discounts on eye care, prescriptions, savings on travel, dining, and deals from top retailers. So many ways to save. Instant resources, tools, and tips to help manage your money, maximize your health, and so much more. AARP is mobile. Get alerts to savings and events near you. And AARP is the largest advocacy group for people over 50. Your voice will be heard.
I love the local retail discounts. AARP absolutely pays for itself.
I'm nowhere near ready to retire, and AARP has been a tremendous resource for that.
I get reliable financial tools and tips.
And we check out the hotels, the dining. AARP saves us a lot of money.
Join today for just $12 for your first year. That includes a second membership free. Plus, you get the award-winning AARP The Magazine.
I love the magazine. Everything in there applies to me.
Benefits for both memberships start instantly. So call or click to join AARP today, and you get this travel bag and AARP The Magazine free.
Call 1-800-411-8550. That's 1-800-411-8550.
Or go to getaarp.org.
two trials for you live today. The first is Florida versus Jonchuck. Just so you know, the witness that was testifying is off the stand now, so we have a short transition during that trial. Ohio versus Lindsay. That is the one that we've also been covering. We'll continue to cover that online as well as live. They were on a break a bit ago, so we'll stay tuned on that trial. Now, here's what I want to talk about, and Paula, I want to bring you back in. What's interesting in this case, this is the second witness the defense has called that was already called as a witness by the prosecution. So they've testified, they've been cross-examined by the defense, prosecution arrested, defense presents its case, and they've recalled two of these witnesses. Why might they do that strategically?
Well, I think there can be different reasons, but in this particular instance, I think that there was some follow-up done after he testified, and the defense wanted to go into the follow-up. This is an example. We talked about stipulations before. They could have probably, I'm sure the prosecutor would have entered into a stipulation, but sometimes defense lawyers like having the live witness in the courtroom, and it's certainly easier for the jury to follow, and if you have physical evidence, it's easier for the jury to understand, but there are other instances, but I think here they were just following up.
All right, so that's what the defense has been doing in this case. Here's another thing I want to talk about, and that is this defendant's father. Who better to testify as to how he would act, what his behaviors were like? He was at his father's home the night he left with Phoebe. So let's listen to some of, and this is Jonchuck Sr., the defendant's father, to some of his testimony.
He was living with you in around Christmas time. Did John pour salt around the house?
Yes.
Did he pour salt around the windows?
Yes.
Did he pour salt around the door to Phoebe's bedroom?
I don't know about that.
Did he tell you what the salt was for?
Objection, Judge.
He said that John poured salt around the house and the windows.
I was unaware of that at the time until I happened to be looking out one of my windows one day and I asked about that.
Okay.
Because I didn't get to elaborate on it when you asked me the question.
Yeah, and I'm going to ask you again. Did he tell you why he put the salt there?
Apparently it's to keep out evil spirits.
There's the defendant's father talking about salt that he put around in the house. What did he know, if anything, about the last time he saw Phoebe? Let's listen.
The last time you saw him on January 7th, do you know what the time was?
That night, I mean, this happened on the 8th, correct?
Right. You had dinner, you had the sausage and eggs?
Yes.
Did you go to bed?
Yes.
What time?
We all went to bed, I want to say between 10 and 10:30.
Okay. You think that Phoebe and the defendant were still there at 10 or 10:30?
Yes.
Okay.
As far as I know, I want to say to the best of my recollection.
Okay, that's all we can ask.
Okay.
Did you hear them leave?
No.
When you woke up the next morning, were you surprised they were not there?
Yes, kind of.
At that point, you did not know where he had gone or what he had done?
No.
So that's the defendant's father. Now, if you've read or been listening to Law and Crime, you know there's a journalist from Tampa Bay that was covering this story and has been covering this story. He's been on Law and Crime with us. And he wrote a lot about the childhood of Jonchuck. And what that revealed is that allegedly this father, when he did have Jonchuck in his custody, which was not consistent throughout his life, there were marks, there were bruises, the police were called, he hated his father, he tried to attack his father with a knife. So by all accounts, Paula, his father is not someone that treated him well growing up. The jury may or may not know that, but when you know that, does that make a difference in terms of how his testimony is received or how you hear his testimony?
I think that one of the jobs of a lawyer when you're putting a witness on is to be in the background, but you really want to give life to that witness and their testimony. And you're sort of painting, a canvas, so to speak. And it does help when you know all of that background and the witness may say something and that sparks, a memory that you have of a conversation you had with this witness, or you know something from the past. For example, you're talking about, the fact that it was not an idyllic childhood. And in this case, I think that's very important for the jury to understand, because as you sit there and relate to this witness, I mean, he looks like, the father himself looks like he might have some mental issues. That's the way, when I look at him, he's a little bit disheveled. I think, the jury's looking at all of that, trying to figure out where this man came from, how he was raised, was there mental illness in the family. Mental illness is very often something that's inherited, and I think that's something that's been touched on in this trial, that the mother was addicted. The defendant's mother, Mr. Jonchuck, his mom was a crack addict, and the issue was whether she was using crack when she was pregnant with him, what his early childhood was like. So all of those things matter.
I think they do too. And, he arguably is pretty hardened to me when you watched him testify. He lost his granddaughter, very young child, who he knows was thrown off a bridge to her death. He's testifying against his son, but yet you don't really see any emotion. I think that's got to be something else that the jury takes into account.
Yeah, I completely agree. You wonder what this little girl's life must have been like living with these people.
Yeah, it's a really horrible case. The other part of this is complex trauma for children. And so there's a picture of Phoebe, but her father, Jonchuck, had complex trauma, which are repeated incidents of trauma that are caused at the hands of a caregiver, and science now shows that causes all kinds of changes to the brain chemistry, to the development of the brain, and can necessarily affect later on behaviors by adults. And it might be that in this case. Having said that, I guess my question to you is, does that even matter? Again, the jury has to look at whether or not he was insane when he committed the crime. So just briefly, does it even matter about his childhood? I'm going back and forth because who cares, really? We're all having to focus on, was he insane at the time or not, as the defense alleges. As a jury member, that's what they have to decide.
Well, I think if the defense is that he has a history of mental illness that stems back to his childhood, then it's relevant. But also in this particular case, the prosecution has made his childhood relevant, because if you recall, the prosecutor put into evidence the fact that when he was 12 years old, he was contemplating his future, that he would use mental illness as a defense. So suddenly what happens in his childhood has become relevant.
It is. So your prediction, just in one word, we have to go to a break shortly. What do you think?
I think no. I think no. I think juries are very reluctant to find insanity.
Okay. All right, taking a break. We're coming right back. Good evening. We're going to go to Daily Debrief next.